The Human Rights Act of 1988. So I'm going to start by telling you a little bit about the independent judiciary in the UK. So it was changed by Blair in something called the Part Separation of Powers, which meant that before Blair introduced this change, there were law lords who sat in the House of Lords and therefore created legislation and then also interpreted it. And they were appointed by the Lord Chancellor, who was appointed by the Prime Minister. The fact that they were appointed by someone political, even if indirectly, made them seem less independent. And so to make them more independent, Blair helped introduce a new system, including an independent judicial appointments commission, which replaced the Lord Chancellor. And we now have a Secretary of State for Justice / Lord Chancellor who's taken up this title, however, not the role. And the role is now of an independent commission who appoint judges for life, which makes them more independent. And they also have a fixed salary, which also makes them more independent. And a lot has been done to make it less biased towards a political system. Now, the judges cannot strike down legislation as they can in America under the American system. They can only declare it ultra vires, which means it's beyond the reach of the law at the point. However, if a government wants to, at this point they can just change the law to make it so that they can pass a new law. And an example of this is the benefit changes under Ian Duncan Smith, which were declared to be ultra vires, therefore beyond the reach of the government's power, and so the government just changed the law so that they were able to do this. Now on to the European Convention on Human Rights. It was ratified by the UK in 1951 and came into force in 1953. However, the UK government and public services could not be taken to court by the British people until 1966. The Human Rights Act essentially means that the European Convention on Human Rights is part of UK law, and it helps to include it into the UK law to help show that Parliament is sovereign. And it also makes it easier for people in the UK to take the government to court or take public bodies to court, because going to Strasbourg, which is where the European Court of Human Rights is based, can be quite difficult, whereas allowing the British judges to interpret European legislation makes it easier for the British people, and therefore arguably it is more democratic. Now, even though the Human Rights Act was introduced in 1998 as a law, it was not until 2000 that it took force, as it took 2 years to train the judges for it in unconscious biases such as unconscious racial and sexist biases that the judges might have, and this helped make them even more independent. The problem with the European Convention on Human Rights and the Human Rights Act is that the government is still above the Act, which means that judges cannot strike down any legislation if it is against the European Convention on Human Rights. It can only declare it incompatible. Luckily, the UK government tends to agree with the European Convention on Human Rights and therefore abides by it if it does something that is incompatible. However, the one occasion where they have not abided by it is in giving votes to prisoners, meaning they have decided that they will not allow prisoners to vote, even though this goes against the European Convention on Human Rights. Now for a comparison to the American system. The First Amendment of the United States Constitution guarantees freedom of religion, speech, press, and assembly. An example of this is the Native Americans wanting to use a strong psychedelic drug called peyote for religious purposes, and the court ruled that they were allowed to use it for religious purposes. However, Rastafarians were not allowed to use weed as it was a newer religion. So this shows that the US Constitution does tend to protect rights more than perhaps the Human Rights Act. However, there are still cases when it does not. And that was a short summary of the Human Rights Act as well as the European Convention on Human Rights and a comparison to America and its human rights in the Constitution.